So I already talked to you about your claim of exemption. You receive one, you need to review it. Ask, are the funds that they're claiming, because they can do a claim of exemption on a bank levy. The claim of exemption on a bank levy is going to be a little bit different. It's going to usually not be based on basic necessities of life, but on the fact that the funds in the bank account can be traced back to something that's exempt. So you're going to look at it. If they've got all their payroll going directly into their bank account, within the last 60 days, and it's just their account that all their money goes into and their money goes out of, and it's all recently been deposited, you're going to still be hit by that 75% exemption. So if they're not claiming it completely exempt and just saying, hey, and they do their declaration as part of their thing that it's exempt because it was deposited in the last 30 days from my paycheck, whether it's worth, and they're only claiming the 75%, yeah, go with it. That's probably where you're going to be anyway. Save yourself some time and effort unless you're particularly obstinate about it. Likewise, things that will be exempt, direct deposit, Social Security funds, anything that can be traced back to private or public retirement, with some exceptions. So actually go through the exemptions and see, is what they're claiming actually exempt? It may save you some time, and be ready to jump on them if it's not.
Is that something that you can actually, in discussing with your debtor, can you actually discuss where their income comes from so that you know whether it's even... When
you're doing like your order of examination? Yeah. It's like because what you can do is, you ask them, are you employed? And they're going to say yes or no. If they're not employed, are you retired? Are you receiving Social Security? All of these things would allow you to determine it, and if you've done your examination and you've got a judgment debtor and they've testified that they receive nothing but Social Security, own no property, things like that, well, truthfully, unless they win the lottery, you're probably never going to collect against them. So it's up to you to determine how much effort you want to put into it.
And disability is the same as Social Security, it is exempt as well.
Generally, but the list of exemptions, there's a list of exemptions, and the amounts are always evolving. Every 3 years they update them. So for example, pensions are generally going to be exempt. They're only exempt as to the extent that they're necessary for the necessities of life. So I've seen the court exempt surprisingly large pensions, just so you know. But if, for example, a person is retired and they're getting $12,000 a month from all of their pensions, then you could probably make a pretty good case that maybe it's not all necessary. It may be worth a shot. But look at what their funds are. It's up to them to prove the exemption. So they're going to have to provide information as to why they're exempt. Now, if they're doing it supposedly on the basic necessities of life, are their requests actually reasonable? Is what they're saying actually reasonable? If you do a few of these, you can get a pretty good feel over what each court is going to do as far as determining whether it's exempt or not. And then, if no, you would file your opposition to the claim of exemption and notice of hearing on the claim of exemption. This brings us to judgment liens on real property. This is where the abstract of judgment comes in. An abstract of judgment is simply a document that says this is what the judgment is in the court and can be recorded at a clerk recorder's office. An abstract of judgment, the form is Form EJ001. Caption is just what you'd expect, except there's one little tweak on it. It says here, recording requested and returned to, and that language is necessary for the recorder's office to actually record it. And then it just indicates whether you're the attorney for or the judgment creditor. And then the address of the court, the plaintiff, the defendant, judgment creditors, is going to be checked if that's you. Last known address of the judgment debtor, the Social Security numbers, if you know them, last four digits of the driver's license, if you know them, a checkbox for unknown. And then you put the address where the summons was served. I accidentally left it blank on this form. Don't do it on yours. But you would put the address where the summons was served, and then the name of the judgment creditor, that's you, then you date, sign, and then the judgment information goes down below, starting at line 6, the amount of the judgment, the date the judgment was entered, if it was renewed, the amount of the judgment, the date the judgment was renewed, that a stay has not been ordered, and that there are 2 checkboxes, 12A and 12B. If your judgment is kind of complicated, you'll probably want to check 12B and attach a copy of the judgment. But if it's a straightforward, 1 or 2 page judgment, you can check box 12A and the clerk will just certify that this is a true abstract of the judgment. And then once this is all complete, it's $25 to issue it, and then you would take it to the clerk recorder's office and have them record it. And they will actually, if you file it there at the clerk recorder's office, they will record it the same day. And assuming that they did it as just the first 2-page document, that the standard abstract of judgment, currently it's running $24. If you attach a judgment to it, there's an additional $3 each page. So it's to record these in the court, $21 for the first page, $3 for each additional page, and the abstract of judgment is at least 2 pages long. Just one thing that also popped up. Your abstract of judgment, just like the judgment itself, is valid for 10 years from the date of the judgment. So not the date of issuance of the abstract generally, with a few exceptions dealing with governmental entities and so on. But on a normal civil judgment, 10 years from the date of judgment itself, at which point, once that's expired, the lien is just no longer enforceable. You can file another abstract of judgment anytime you renew a judgment. So you can file it on the renewed judgment, and then it'll run 10 years from the date of the renewed judgment. Yes?
Now, can they use the exemption for the real property?
No, because in this case, all of that this is doing is it's recording a name lien against a person. So if the person owns any real property, or if they purchase any real property, or gain any other interest in real property that's being recorded, this lien will attach to it. So if they then sell it or refinance it or something, the lien either needs to be cleared if there's going to be any sort of equity after any creditors first in line, like the mortgage company.
And how the homestead will apply to this?
The homestead just protects potentially the house from being sold out from under you. It doesn't mean that just because it's homesteaded, once you sell it, it's no longer your homestead. If you sell it and you take and you're getting money from it, well, you have to clear the lien. But all it does is it just passively sits there on the property. It's not going to force anybody out of the property, which is what the homestead exemption is designed to protect against. It protects the minimum, it protects it from being sold out from under you unless a certain amount can be paid to you from the proceeds. All right. Some other techniques that you might want to consider: if your judgment debtor is a business, consider the till tap. Or it's also known as having a keeper. Basically, you do a writ of execution, you fill out a request with the sheriff, and then you have a sheriff's deputy sit there, count out the money at the register at the beginning of the day, and then just stand around there for the next 4 or 8 hours, depending on how long that you've hired them. And anytime a customer pays by check, they make it payable to the sheriff's department. Anytime that they put money, they put it in the register, and then at the end of the day, the sheriff counts back what was in the register to begin with and takes the proceeds that were received. This is particularly useful if you're dealing with a business that has a high volume of customers, restaurants, restaurants, salons, stores that tend to have a fairly high volume of customers, especially if they're doing a lot of, transactions where it's not, the store issuing credit on something, where they're actually paying cash, writing checks, etc. The few situations where this is particularly useful is, well, first, if they have the money, but second of all, if the business, doesn't like the idea of having a sheriff's officer standing around counting out the money, and their customers might not like it. It puts a little pressure on them. I'm still waiting to see one of these used on, some businesses like medical marijuana dispensaries and things like that. Yes, even though, the person's not doing anything illegal, some of their customers might not appreciate it. But it would definitely, a till tap, one or two till taps over the course of time is oftentimes very useful in getting a business to work with you on creating some sort of repayment plan to avoid the inconvenience. Seizure of personal property. This is going to be pretty rarely used, but when it is available is particularly fun. Reason that you're not going to use it too often is the exemptions that people have in their personal property tends to be pretty high. For example, if you want to get somebody's automobile, I'm trying to remember the current exemption amount, if it's about $3,000 around there. Basically, that would mean you'd have to be able, before you can get an order to sell the vehicle, you would have to be able to show the court that you could pay the sheriff $1,000 to have them take the vehicle, have the vehicle sold at auction, pay all the auctioneer fees, pay off any other creditors who have secured interests on the vehicle, pay the judgment debtor their exemption amount, and still have money left over to pay yourself. Now, given the fact that when you take a vehicle to auction, you're maybe getting 30 or 40% of the value of the vehicle, unless the person is driving around, and most people owe more money on their vehicle than it's worth, unless the person is driving around in a shiny new Jaguar that they own outright, probably not worth your while. Nonetheless, if they are, the instant one of these possibly hits, if you happen to attach somebody's precious Jaguar, they will usually work with you right away to find a deal with you. Other types of personal property are usually not going to be that appealing as well because, like with jewelry, all these other things, the exemption amounts are so high that it's very rare that you're going to actually find something that most people have that you can actually attach to. Sale of real property. Also, this is going to be pretty rare, especially in today's economy. If a person resides at their property, they have a homestead exemption in it. This homestead exemption is going to range anywhere from $75,000 to, I'm trying to remember if it's $175,000, depending on, actually they raised it up. Yeah, depending upon the person who's claiming it. Basically, this homestead exemption, if they've recorded a homestead, if they've recorded the homestead exemption at the clerk recorder's office, it's up to you to disprove that it's their homestead. If they haven't, it's up to them to prove that it's their homestead, but that's really easy. They just show they're living there. And the exemption amount should have to be able to show that, once again, the property could be seized, auctioned, all the mortgages paid off, and pay them their entire claim of exemption, or their entire homestead exemption amount, and still have money left over to pay you. And I don't know about you, but I don't know too many people who have much in the way of equity in their personal in their houses at this moment. So you're probably not going to hit that. However, where you may be able to get them, and may be able to seek to foreclose on is if they've got investment property. Keep in mind, however, that their investment property has to actually have some equity in it. So when you do your review at the clerk recorder's office and you pull the deed, you'll be able to see not only information, you'll be able to look and see who they've mortgaged it through and get an idea of whether or not it's likely that there's going to be any sort of equity. And if there is, it's maybe worth considering going after. Once you bring an action to foreclose on their property to deal with this, if they're at all attached to their investment property, then that will also oftentimes encourage them to work with you, because it's much tidier for everyone if they just pay you. And if your case happens to be a motor vehicle accident case, it only applies to motor vehicle accidents. The most effective way probably to encourage the other side to maybe work with you is to suspend their driver's license. And so if you have a motor vehicle case, the other side hasn't paid, you can actually use Form DL-30 through the Department of Motor Vehicles and ask to suspend their license. And their license will remain suspended until they either pay off the judgment, pay $5,000 toward the judgment, or 3 years have passed and they've applied to have their license reinstated and they've provided proof of liability insurance to the DMV. The reason that this latter one is the whole purpose of this is to put pressure on them, and if they haven't paid you in 3 years or entered into a payment arrangement with you, it's not going to do any good. But
You read suspended? They still owe you.
they still owe you, but I've actually never had that question because it's usually been, you know, I suspect that probably not just because it doesn't seem equitable to do so, because the reason they're allowed to reapply, it would be like trying to get a contempt order, and then, you know, after that sort of, hey, have another one on the same thing, and again and again. But, you know, that's a question worth looking into.
There's something about, I had a gentleman that we suspended. He made a payment agreement. So we let him reinstate the driver's license. Then he turns around a week later and files bankruptcy. Now we're biting that one.
Right. Well, you know, if the debt is dischargeable themselves, because that's a risk any time that you're dealing with any sort of collection. You know, unless you happen to be in the very small category of things that are not going to be dischargeable, like student loans, you always run the risk that the judgment debtor is going to go bankrupt. And if they go, you know, if they file a Chapter 13, you participate, you hope, you know, get a piece of the repayment plan, and you're done. If they're doing a Chapter 7, you know, evaluate, you know, participate in the meeting of creditors, determine whether or not it's worth, you know, doing an adversarial proceeding to try to get yourself held out of it. You know, instances where it is especially if the debt is through fraud, you know, or something else that, you know, fraud, criminal culpability, things like that, where there's, you know, they've just done bad things. You know, if you're in a car accident, yeah, it could get discharged. You're in a car accident because the person was driving drunk down the road backwards, were hanging out the sunroof and driving with their feet, you know, on the wrong side of the freeway. Yeah, you could probably get that out. Anything between, you know, the two, it's anybody's guess. Yeah, the federal courts tend to be funny sometimes. And there's certainly a few things I'm happy to stick around and talk to people individually afterwards, after the recorded presentation, but this is it. You may not get your money, but you've got some tools to try, and hopefully you've got you will get your $2.
Do we get samples of those forms that are in your presentation? Like samples of how they're filled out?
Available online?
They are available. Most of these that I've talked about, the library actually has guides on most of them.
Oh, okay, cool. Thanks.
All right, thank you.